Hey folks, this is your friendly, experienced lawyer again. In our first two videos, we talked about student loans and the amount of debt that one would have to undertake or assume if one is going to go to law school. And I had the story about the client that had 250,000 in student loans and that of course is not dischargeable in bankruptcy. Very important. Um, and then we talked about some of the aspects of the practice of law itself in video two. Um, I went back and I did some numbers on the student loan. You gotta remember, you're not gonna have a job, so you're sort of falling behind what those people who just got bachelor's degrees got. You're gonna be out of action for about 3 years. Even if you work part-time, it's not gonna totally make up for that. But let's just assume that you come out with $100,000 in student loan debt. Now, I think traditionally student loans had to be repaid in 5 years, but they do give extensions. I mean, this gets to be very muddy, this area. But if you even cut the amount of debt that you assume, a student loan to $100,000 at 6%, that's an extra over 5 years. It's almost $2,000 extra in monthly payments that you're going to have to pay in the earlier years. In your early years, and you naturally you're going to want a house and you're going to want a nice car and all that kind of stuff. If Student Loan Authority, Sally Mae or whoever's running that operation now, if they extend it out to 10 years, you cut your monthly payment to $1,110. You're basically talking about anywhere from an extra housing payment to two extra housing payments a month if you go to law school. So you jolly well better make that up in salary, and the competition for those jobs is very intense. Just to give you an idea, the numbers I came up with a $100,000 loan, student loan, that's $1,933 a month. If it's financed over 60 months, that's assuming an interest rate of 6%. And if you finance it over 10 years, that's a monthly payment of $1,110 that you're going to have to cover extra, versus a home payment on a 30-year fixed rate mortgage for a $250,000 home. Now, this is not assuming any escrows for taxes and insurance and things like that, but the monthly payment just on the mortgage loan is just a hair under $1,500 a month. So you can see that 30-year mortgage basically fits between the two numbers I just gave you, but it's very expensive to go to law school, and you need to recover those expenses. Okay. This all gets to the subject of this video, which is going to more or less be about competition. You're not only going to have to compete with your fellow law graduates to get jobs when you get out there, you're also going to have to compete with other firms that are not non-lawyer firms. And I'm talking, for example, about Notary Publics offer services. A lot of paralegals get out there and offer services. Sports agents, real estate agents write contracts and things of this nature. There are people that want to represent folks with respect to things like timeshares and all this kind of stuff. And what constitutes the practice of law has changed over the years. That's a very complicated subject. I would just tell you this: you can take brain surgery, and if you split it up into a whole bunch of each task that a brain surgeon performs, if you split up all those tasks into smaller and smaller tasks, pretty soon you could put 1,000 idiots together to perform brain surgery if they all know they're 1,000th of a bit to do. And so it gets, when you get to practicing law, you run into the same problem. You can split up the tasks, and if you do so, pretty soon you're taking out the garbage, and it's something that's very, very simple. In other words, it's lay people have taken rather mundane aspects of the practice of law and have started doing that. And what really becomes irksome to lawyers is it's taking business, but these folks eventually, you can't help but to inevitably have to practice law, to have to give legal advice, to have to make certain judgment calls about the law that actually constitutes the practice of law. But that's another discussion. But so you're going to have competition from various sources out there, which all gets to this notion that you're going to, in the marketplace, in practice, you're going to be competing against other lawyers for business. We spoke a little bit before about how regulated advertising is for lawyers. It's not like most companies. You can't just willy-nilly do what you want to do. We discussed that in the previous video, but there's no question that advertising as an expense is becoming a bigger issue. You know, I've been a sole practitioner for several years. It's nothing to spend between $1,000 and $2,000 or maybe a month, and a lot of the personal injury firms spend way more than that. I mean, they would find that figure probably to be laughable. And meanwhile, you're trying to cover your student loans, I might add. But if you're spending, you know, $1,500 a month on advertising, say like, you know, on some of the search engines, that $1,500 in the market in which I deal with, that is more than you typically can get in a fee for example, a criminal misdemeanor case. It's more than what the legal fees, now I'm not talking about title insurance and the title searchers here, but it's more than the legal fees that you typically can get on for a residential real estate closing. That is also more than the typical fee that you can get for a Chapter 7 bankruptcy. It's also at least twice of what you typically can get for what I call a non-estate planning, simple I love you will, where there's not going to be a taxable estate. So you're talking, I would say by and large, at least 1.5 clients to 2 clients per month that you got to cover just to cover your advertising costs. We're not talking about your rent or your student loans. So that, and given, like I said, the fact that you know, most folks cannot afford extensive legal services, and you're going to be up against a lot of law firms that are out there for that business also, and they're better capitalized than you are, and they can do more advertising, more likely to be able to hire non-lawyers, namely like paralegals or just even secretarial staff, to handle a lot of those tasks. But you've got to be capitalized in order to do that. There's no question that well-capitalized lawyers that can carry cases, and especially carry cases, especially for those those plaintiff's personal injury cases, without a fee, and to take the chance on losing the case, they are in a lot better position to be profitable than the little guy who's basically trying to practice law pretty much on a shoestring. It's a very tricky business, and it's one reason why I talked in the last video about the escrow rules. Even if you've collected fee, for example, I'm not talking about third-party money that you hold in escrow like to settle a real estate closing. But like if you've collected fees in advance of the rendition of services, they've got to be put in escrow, and it's just like I pointed out last time, even if they're going to cut off your lights, and even if you're going to be evicted from your office, you can't touch that escrow account until the services have been performed. And then especially a lot of times in litigation, those services will not be performed until several months in the future. Financing the cash flow issues related to the practice of law, handling the time and expense associated with complying with escrow account rules, both types, one for prepaid client fees and the other one for third-party monies that are going to be, that aren't your money to begin with, and you're handling the money for somebody else. Between those two things, it's a lot of time, expense, and energy, and bookkeeping costs. But it's one reason why a lot of lawyers get in trouble with the bar regarding escrow accounts. It's very, very tricky. Oh, here's another biggie. You know, a lot of companies, if they're not being paid, or if they're dissatisfied with the party on the other, a customer, or with the party on the other side of a transaction, you know, assuming that they can do so without violating a contract or something, will just stop work and they'll just leave. If you're not happy with your employer, you just walk out the door. But if you're talking about handling a client's legal case, a litigation matter, a matter that is before a court, whether civil or criminal, if you all of a sudden don't like your client, you feel like your client's doing you dirty, or let's say they're not paying their monthly legal bills, you actually have to go through the time, expense, and energy of filing a motion before the court to withdraw from the case. And until the court grants you that permission, you are still ethically responsible for handling that client matters. They're legal matters. Okay, that's going to about wrap up video 4. I hope that you'll stick around for our next video. Hopefully we'll pack that full of useful information for you as well. Thanks a lot for watching, and we will see you next time.